just the phone.
Day you walked away, you were the clock that was ticking in my heart. Changed my
Hello?
mind.
Ladies and gentlemen,
Love so hard to find.
we got him.
Hello.
Ari Dynar, the defendant, contacted a former associate known as Lucky Simone regarding potential investors in the money laundering scheme. What he didn't know was that Mr. Simone, an American from Nevada, had become a confidential informant of the FBI and, under their supervision, connected Mr. Dynar to another undercover informant to begin setting up a sting operation. Through many recorded telephone conversations, the informant asked Mr. Dynar to launder large quantities of money that was explicitly stated to have been acquired through illegal trafficking, to which he agreed. In anticipation of the first transaction, Mr. Dynar believed that he would be arrested upon crossing the American border and instead sent an associate to collect the money at a planned location in Buffalo, New York.
We must abort the attack. The game has changed.
What are you talking about?
The financial transaction did not go through at the meeting, and the FBI sting operation failed. The United States government charged Mr. Dynar with attempting to launder money and one count of conspiracy to violate Title 18 of the United States Code, the main criminal code of the federal government. They then requested for Mr. Dynar's extradition. On the Canadian side, the following legislation are relevant to the case. The Criminal Code Section 462.31, which pertains to laundering, Section 24 regarding intention to commit an offence, Section 465 which has provisions regarding conspiracy, the Narcotic Control Act Section 19.2 which also pertains to laundering, and the Extradition Act 1985 Sections 9 subsection 3 as well as Sections 13 and 18 which detail the responsibilities and objectives of the judge in extradition hearings.
The testimony contradicts the evidence. No.
Mr. Dynar, the appellant, was indicted and extradited together with Maurice Cohen, the co-accused, in the United States District of Nevada after a failed sting operation by the FBI. A committal hearing was held before Justice Keenan of the Ontario Court, who found that the conduct of Mr. Dynar would constitute an offence of attempting to launder the proceeds of the crime. Despite Mr. Dynar's charter objections regarding the use of wiretap evidence, Justice Keenan relied on the wiretap evidence to grant the extradition, even though this evidence would not be admissible in Canada. Notwithstanding the criticism around the wiretap evidence and the lack of Canadian involvement in the investigation, the minister agreed with Justice Keenan's decision and ordered Mr. Dynar to be extradited to the US. Mr. Dynar appealed this decision to the Ontario Court of Appeal and also made an application for judicial review on the minister's decision to order a surrender. Justice Galligan, for a unanimous court, allowed the appeal and the application for judicial review on the basis that the activities of Mr. Dynar would not constitute a criminal offence in Canada. Justice Galligan noted that, although in the US a conviction of attempt is complete if a person acts on a representation that the property obtained is the proceeds of a crime, in Canada the accused cannot rest on a representation, but is required to actually have knowledge that the money is the actual proceeds of a crime. Justice Galligan granted Mr. Dynar a complete discharge, which the minister and the US appealed. Mr. Dynar cross-appealed on the grounds that Canadian authorities violated his right to a fair hearing by failing to disclose Canada's involvement in the US investigation.
I didn't do it.
The first major issue at hand is whether Dynar's conduct would have amounted to an offence under Canadian law if it had occurred in Canada. A finding that his conduct would have amounted to an offence under Canadian law is required to meet the necessary double criminality requirement for a Canadian fugitive to be extradited for a trial in a foreign jurisdiction. This more broad issue breaks down into two more specific issues premised on Dynar's conduct. Whether an accused who attempts to do the impossible may be guilty of attempt. Specifically, whether Dynar's attempted laundering of money that was not the proceeds of crime could constitute an attempt, and whether an accused who conspires with another is guilty of conspiracy. The second major issue presented by the cross-appeal is whether the Canadian authorities, by failing to disclose details of Canadian involvement in the US investigation of Dynar, violated Dynar's right to a fair hearing as guaranteed by the Charter under Section 7. This issue is primarily focused on if Dynar was entitled to receive disclosure of evidence gathered by the Canadian state during the investigation.
Kwok, analysis. All evidence indicates. I ate too many cheesy dibbles.
Round 1. Fight!
The court begins by discussing the issue concerning attempt. First, there are two statutory provisions under which Mr. Dynar's attempt at money laundering could have been prosecuted by Canadian authorities. Section 462.31 subsection 1 of the Criminal Code and Section 19.2 subsection 1 of the Narcotics Control Act. To be convicted, both statutes require that the accused be aware that the money converted was the proceeds of crime. The conversion of monies that are believed to be the proceeds of crime, but are not, was not an offence in Canada at the time of the proceedings. Mr. Dynar could not have known that the money he agreed to launder was the proceeds of a crime, since it is not possible to know what is false. This leads to an important distinction between imaginary crimes and factual and legal impossibilities regarding criminal attempts. A factual impossibility is an attempt that cannot be completed due to an obstacle. For example, a pickpocket attempt where the victim's pocket was empty. Legal impossibility is an attempt that, even if completed, would not be a crime. An example of this is smuggling a substance believing it to be a narcotic when it is in fact just sugar. An imaginary crime is the thought that an act is a crime, but it is not. An example of this would be consuming marijuana while unaware that it has already been legalized. Mr. Dynar argued that his conduct was an attempt to do the legally impossible, which could therefore not be considered a crime. This argument was ultimately rejected. The defense of legal impossibility could not apply because the criminal law of Canada only recognized a distinction between an imaginary crime and factual impossibility. Given the fact that Mr. Dynar took steps to realize his intention of money laundering, there was sufficient evidence to establish that Mr. Dynar's conduct fell into the category of the factually impossible. He attempted to commit crimes known to law and was thwarted only by chance. This was a criminal attempt within the meaning of Section 24, subsection 1 of the Criminal Code. Concerning the mens rea of the offense of attempt, the circumstances, or absences thereof, are not relevant. An accused is guilty of an attempt if the intention to commit a crime is present and steps are taken towards its commission. It is belief that one is engaging in an unlawful act which establishes a mens rea. If the mens rea of the criminal act is present, being thwarted by circumstance cannot save an accused who had the intention to commit a crime. The primary purpose of the law of attempts is to discourage individuals from committing future offenses. While imaginary crimes fall outside the scope of this purpose, factually impossible attempts are equally as menacing to society as an attempt, as the only difference between the two is chance. Although Mr. Dynar could not have laundered the proceeds of crime in this case, there was no guarantee that these circumstances would not repeat with his next client. The intention behind Mr. Dynar's conduct remained to be a societal risk.
Round 2. Fight!
Next, the court considered whether Mr. Dynar's conduct could justify his surrender on the conspiracy charge. Criminal conspiracy constitutes a serious offense in Canada and is extraditable. It is recognized in the 1976 treaty between Canada and the US, which was in force at the time of Mr. Dynar's actions. This is because the scale of harm caused to society can be far greater when two or more individuals conspire to commit a crime than when a single individual sets out to do an unlawful act. The act of conspiring is the actus reus of the crime. The Crown is simply required to prove a meeting of the minds with the intention to do something unlawful. In the case of a police informant who has no intention to do something unlawful, that individual will not be involved in the conspiracy. The conspiracy can still exist, though, between other parties in the same agreement, which is the case for Mr. Dynar. Mr. Dynar attempted to use impossibility as his defense for conspiracy. However, the court found that this did not apply, because impossibility has no effect on the conspirator's intention to do something unlawful. Mr. Dynar and Mr. Cohen's partnership satisfied the requirement that two or more people work in concert. Their agreement to launder what they believed to be the proceeds of the drug trade satisfied the actus reus for conspiracy, and the intention, or mens rea, was satisfied by Mr. Dynar's boastful assurances of his ability to quickly launder large sums of money, as well as Mr. Cohen's appearance in Buffalo.
Final round. Fight!
Finally, the court considered whether Mr. Dynar's charter rights were violated by the lack of disclosure of Canadian involvement. In Canada, the extradition process is governed by the Extradition Act. In order to determine whether or not a fugitive should be turned over to a foreign jurisdiction, a two-step process is undertaken. First, there is a committal hearing where the judge determines if the evidence justifies surrender. Second, if the judge decides that the evidence does justify surrender, the fugitive is committed, and the warrant and other reports are forwarded to the Justice Minister to make the final determination. Sections 13 and 18(1)b protect the liberty of the fugitive by necessitating a hearing that conforms to the principles of fundamental justice and proof that the acts committed would constitute a crime in Canada. However, as Justice Laforêt states, extradition proceedings are not trials. They are an expedited process designed to keep expenses to a minimum and ensure prompt compliance with Canada's international obligations. Mr. Dynar cross-appealed on the grounds that he did not receive the disclosure of Canadian involvement necessary for the committal order. He contends that the lack of disclosure justifies a new hearing with full disclosure, providing him the basis to argue for a stay of proceedings. However, as stated, the purpose and procedure of the extradition process differs from that of the criminal process. Sections 13 and 18(1)b may provide protections, but a relationship between Canadian and American authorities does not need to be disclosed according to both the Act and the 1976 Treaty. The sole requirement of the foreign jurisdiction is to establish a prima facie case for surrender. Furthermore, charter rights only apply to Canadian state actors. The evidence which Mr. Dynar contends was in violation of his charter rights was gathered in Nevada, in conformity with Nevada's laws and by American state actors. As such, the Canadian charter does not apply.
The extradition hearing was presided over by Justice Keenan of the Ontario Court of Justice, who allowed the extradition. Mr. Dynar then appealed to the Ontario Court of Appeal, which was allowed on the grounds that Mr. Dynar's actions would not constitute a crime in Canada, which is a requirement for extradition. To be convicted of money laundering in Canada, two elements not found in US law must be satisfied. The money was actually sourced from crime, and Mr. Dynar had actual knowledge as such. In the Supreme Court, they overturned the Court of Appeal's decision because Mr. Dynar attempted and prepared to commit money laundering, which would be enough for a conviction. The Supreme Court also dismissed Mr. Dynar's cross-appeal since evidence was gathered in the US, which is outside the reach of the Charter.
All relevant legislations, the Criminal Code, Extradition Act, and Narcotic Control Act, are under federal jurisdiction. The Supreme Court of Canada allowed the appeal of the United States government and denied Mr. Dynar's cross-appeal. Since the final decision was made by the Supreme Court of Canada, and all Supreme Court decisions are binding across all Canadian courts, the decision of the United States of America and Dynar is binding in all courts and jurisdictions across Canada.
However, I disagree.
Justices Sponica, McLaughlin, and Major delivered their concurrence and partial dissent. The justices stated they did agree with Justice Corey and Iacobucci on their disposition of the appeal, but disagreed with the way they reached their conclusion. The justices noted that it should not be a criminal attempt to do acts which, if completed, would not amount to an offense in Canada. The justices noted that since Mr. Dynar did not know that the money sought to be laundered was in fact a prop by police and not the proceeds of crime, he did not have the requisite mens rea to be convicted. The dissenting justices also disagree with the majority's understanding of the word knowing. The justices note that knowing and believing have different meanings despite the majority's view that they are one and the same. They explain that Parliament is aware of their options and have clearly decided in other legislation to explicitly include belief as a requirement of the mens rea, but have not done so here. However, the justices did agree with the majority on their finding of conspiracy to launder money on the facts. They found that Mr. Dynar did commit conspiracy as the charge is based on the agreement to commit the general offense of money laundering, which does not require the actual proceeds of a crime to be present. Therefore, Justices Sponica, McLaughlin, and Major found Mr. Dynar was properly extradited on the conspiracy charge only, allowing the appeal and dismissing the cross-appeal.
Bye.